Good morning, everyone. I hope you're doing well. Today we're going to talk about a little bit about a very, very touchy subject, and it's about abortion and Jewish law. What does Jewish law say about the fetus? We're going to read that. It says here, an unborn fetus in Jewish law is not considered a person. In Hebrew, it's nefesh, and the soul, until it has been born. The fetus is regarded as a part of the mother's body and not a separate being until it begins to egress from the womb during parturition, which is childbirth. In fact, until 40 days after conception, the fertilized egg is considered as mere fluid. These facts form the basis for the Jewish legal view on abortion. Biblical, Talmud, and rabbinic support for these statements will now be presented. Intentional abortion is not mentioned directly in the Bible, but a case of accidental abortion is discussed in Exodus 21, verses 22 and 23, where the scripture states, when men fight and one of them pushes a pregnant woman and a miscarriage results, but no other misfortune ensues, the one responsible shall be fined, as the woman's husband may exact from him the payment to be based on judges' reckoning, but if other misfortune ensues, the penalty shall be a life for a life. So, if a man is fighting in the street and he knocks over a pregnant woman and she miscarries, the husband of that woman could sue that man for the loss of the child, but if he pushed her down and the woman died, it would be his life for her life. The famous medieval biblical commentator Solomon ben Isaac, known as Rashi, interprets no other misfortune to mean that no fatal injury to the woman following her miscarriage. In that case, the attacker pays only financial compensation for having unintentionally caused the miscarriage, no differently than if he had accidentally injured the woman elsewhere on her body. Most other Jewish Bible commentators, including Moses, Nachmanides, Rambam, Abraham Ibn Ezra, and a whole bunch of others, which I'm not going to pronounce their names, they agree with Rashi's interpretation. We can thus conclude that when the mother is otherwise unharmed, the following trauma to her abdomen, during which the fetus is lost, the only rabbinic concern is to have the one responsible pay damages to the woman and her husband for the loss of the fetus. None of the rabbis raised the possibility of involuntary manslaughter being involved because the unborn fetus is not legally a person, and therefore there is no question of murder involved when the fetus is aborted. Based upon this biblical statement, Moses Maimonides, which I spoke about many times in my videos, go look them up, asserts as follows: if one assaults a woman, even unintentionally, and her child is born prematurely, he must pay the value of the child to the husband and the compensation for injury and pain to the woman. Maimonides continues with statements regarding how these compensations are computed. A similar declaration is found in Joseph Caro's legal code, Shulchan Aruch, No concern is expressed by either Maimonides or Caro regarding the status of the miscarried fetus. It is part of the mother, and it belongs jointly to her and her husband, and thus damages must be paid for its premature death. However, the one who was responsible is not culpable for murder, since the unborn fetus is not considered a person. Murder in Jewish law is based on Exodus 21:12, where it is written, "He that smiteth a man so that he dieth shall surely be put to death." The word man is interpreted by sages to mean a man, but not a fetus. Thus, the destruction of an unborn fetus is not considered murder. Another pertinent scriptural passage is in Leviticus 24:17, which says, where it states, "And he that smiteth any person mortally shall surely be put to death." However, an unborn fetus is not considered a person, or nephesh, and therefore its destruction does not incur in the death penalty. Turning to Talmudic sources, the Mishnah asserts the following: if a woman is having difficulty in giving birth and her life is in danger, one cuts up the fetus within her womb and extracts it limb by limb, because her life takes precedence over that fetus. But if the greater part was already born, one may not touch it, for one may not set aside one person's life for that of another. Rabbi Yom Tov Lipman Heller, known as Tosafot Yom Tov, in his commentary on this passage in the Mishnah, explains that the fetus is not considered a nephesh until it has egressed into the air of the world, and therefore one is permitted to destroy it to save the mother's life. Similar reasoning is found in Rashi's commentary on the Talmudic discussion of the Messianic passage, where Rashi states that as long as a child has not come out into the world, it is not called a living being, i.e., nafesh. Once the head of the child has come out, the child may not be harmed, because it is considered as fully born, and one life may not be taken to save the other. The Mishnah elsewhere states, if a pregnant woman is taken out to be executed, one does not wait for her to give birth, but if her pains of childbirth have already begun, one waits for her until she gives birth. One does not delay the execution of the mother in order to save the life of the fetus, because the fetus is not yet a person. And judgments in Judaism must be promptly implemented. The Talmud also explains that the embryo is part of the mother's body and has no identity of its own, since it is dependent for its life upon the body of the woman. However, as soon as it starts to move from the womb, it is considered an autonomous being, nafesh, and thus unaffected by the mother's state. This concept of the embryo being considered part of the mother and is not a separate being recurs throughout the Talmud and the rabbinic writings.